want to reserve time for rebuttal?
I would like to say 5 minutes. Thank you.
All right, and then just call the case for the record. Mr. Bennett, you may proceed.
Thank you very much, Your Honors. And if it please the court, I am Alan Medbeck. I'm here representing the appellants in this matter on plaintiffs at the trial level, Jerri, DelRossi, and Michael Morlock. This matter is a wrongful imprisonment case arising from a criminal conviction which was reversed by this court. My clients were charged at the criminal trial for events occurring on or about October 27th to 28th of 2012, where they were located in a home which was, for lack of a better word, raided, and they were inside the home at that time. They were convicted, where they were charged and ultimately convicted of manufacture of methamphetamine and possession of chemicals for that manufacture. Those charges were ultimately overturned by this court on Rule 29 acquittal. My clients were, the charges were dismissed, and because of Rule 29 dismissal, those would have been dismissals without prejudice. Subsequent to that, my clients sued for the time that they were incarcerated.
Do you mean with prejudice?
I'm sorry if I said without, I'm losing my mind. Yes, I did mean with prejudice. Those charges could not be brought again because of Rule 29 acquittal, which is a subset of the and they sued under statute 292504A, which articulates a 5-prong test that all 5 of the statutory prongs must be satisfied. We are here solely today on the 5th prong that my clients needed to establish by preponderance of the evidence that they did not commit the offense or that no one had committed the offense. At the trial level, it was undisputed that the first 3 prongs do not apply. And while there are certainly arguments that were made at the trial level regarding the 4th prong, which is whether there were any other offenses that could have been brought by the state against them. The trial court did not rule on the 4th prong and based her decision strictly on a failure to establish innocence. So we are here basically on a factual determination that the facts presented and the manifest weight of the evidence contrary to the verdict of the trial court. And in that regard, the state put on essentially the same case which it had put on for the criminal matter. It called one officer, Officer Crockett, who testified at this trial and at the prior trial, largely to the process of manufacturing methamphetamine and what is involved in that and the process and chemicals involved necessary to make that happen, and to the general method of manufacturing and how manufacturers will use an array of people to bring in chemicals and other materials as a way to try to put off the scent, for lack of a better word. Having a number of people bring in the chemicals rather than going out and getting them all yourself is a way to try to delay being caught. There's some things not at issue in this case. Unquestionably, the owner of the home, Dale O'Connell, was the cook in that case. That's undisputed. He led out to that. He testified at our trial that he was a meth cook. He testified on behalf of Ms. DelRossi and Mr. Morlock that he was a methamphetamine cook, that he had sold meth to them, but that they were not Smurfs, I believe is the word they used. There are a number of them, each with an individual task. I believe that's how we reached that.
Was this meth cooking limited to the basement of the house?
And that seemed to be the indication, is that it was in the meth material was found in the basement of the home, that it was not, and there is no indication that either of my clients were located in the basement. They were there in the living room of the home. It is also undisputed that meth was being done in the home at that time. And we are not here client was never charged with methamphetamine, with possession charge, with paraphernalia charge. These are some of the issues that would be raised in fourth prong regarding whether those cases could now be brought, but that's not the issue before the court here. There are legal arguments that point to the Dover case, both at trial level and in their brief, regarding the propriety of that. There's been some change in the law. Those are not the arguments before this court. That as to whether, because those cases could no longer be brought, even if they were viable, they would be barred by double jeopardy. I don't know that they are yet time barred. Misdemeanors would be. There would be no issue that they could not be brought again, and that is the argument that the fourth prong would be satisfied. But again, and I present that here simply that the error here is not harmless and would need to be decided still below. There's no other question to be had by the trial court. I understand that the outcome that my clients do, that the outcome we're seeking here is remand for consideration of that fourth prong. The evidence presented here by my clients is consistent that they had gone to that home on that date to pick up the neighbor, Jordan Strang. The testimony presented by not just himself, but by Mr. Connell and by the neighbor, who at the time was Jordan Strang's girlfriend, Chelsea Peltz, was that was the purpose for their being there. And if they go to that home, and were they going to do meth is an open question, but it's also not the deciding question here, because they're not charged with that possession. They were charged with manufacturing methamphetamine on or about October 27, 28. And there's a complete absence of evidence to support that claim. As at trial, the witness brought in was Angela Wojcik, who was another co-conspirator who was convicted, who pled and ultimately violated that probation that resulted from that, and ended up doing a significant amount of time as a result of this arrest and charge. And so, as a co-conspirator, and I concede that Mr. Connell also was to be a conspirator in this case, their testimony is to be considered with grave suspicion. The trial court did not give that any consideration. The judge's opinion seems to give weight to what is an inconsistent statement. There is also a fact of time to be considered here, that these are events that occurred in October of 2012. We heard this case in 2018, perhaps 2017, some 5 years on from the events at issue. Obviously the witnesses have, including Mr. Crockett, Officer Crockett, have some recollection issues, and their ability to recall these issues are somewhat circumscribed, I think, based on the time. The state asks why Jordan Strang was not called as a witness, among various other reasons. He was difficult to find. There were inconsistencies. There are recollection issues. That's going to be a case when you're calling something 5 years on. The only person who seems to recall everything clear as a bell with 100% certainty is Angela Wojcik, who's not been involved in any of this for 5 years, and her testimony gets more consistent, or more certain, but less consistent with what has happened at trial over time. Her statements that somehow she recollected 100% for sure, I think, call into question her reliability rather than affirm it, because these are people she had not dealt with in a significant amount of time. Again, the most consistent witness and the person with the least investment in this is Chelsea Peltz, called by the plaintiffs, who is clear that the plaintiffs here, the appellants here, were at the home to pick up Jordan Strang at their request, and that was the basis for their being. If everything else is inequitable, if nothing else is to be believed, she is one person with no investment here, and this is a preponderance of the evidence standard. Like, if that is all that is left, her testimony by itself would be sufficient to find the preponderance of the evidence. Of course, that's not the only evidence here. Both Mr. Morlock and Ms. DelRossi testified, and that's why they were there, that they had gone and they've testified to that effect since 2012. That has been their testimony consistently throughout this case, throughout the lifespan of this time, from the time they got arrested, through their time incarcerated, through to this trial. And I didn't find Chelsea Pellets out of the blue. You know, obviously these were names that they had. This was knowledge that they had. This was information that all of these parties had and brought to the table. Dale Connell is consistent that my clients, that Jerri and Mike, came over to their house, to the house, to get Jordan, that they were going to hang out and maybe do some other things there. That is, Mr. Connell can testify that they were not providing methamphetamine materials for him. Those items are consistent. They're the most reliable witness for the state is Mr. Crockett, is Officer Crockett, who states that that they had no prior knowledge of Jerri DelRossi. There's no indication that Ms. DelRossi was at all involved in this.
You can keep going after your 5 minutes.
I will wrap that up. That even their witness had no evidence that Ms. DelRossi was ever involved in. I will retain that.
May it please the court, Thomas Madden for the state of Ohio, Ohio Attorney General's office. I'd like to thank opposing counsel, particularly in this case, for giving me time to present this argument. In a wrongful imprisonment case, the plaintiff carries the burden to prove before the fact finder that he was actually innocent, and not only actually innocent, but that he committed no crime. The statute was not made for those who avoid criminal responsibility like what happened to the plaintiffs in this case. It was made for those who are actually innocent of the crime. And Judge Oldfield had a lengthy trial, heard all the evidence, and after all the evidence was submitted, she said, I find that Officer Crockett is credible, and I find that Hoysek's testimony is credible because it is in line with what Officer Crockett said. And there's no way that this court can look at this record and say, clearly, Judge Oldfield lost her way. And that's the standard. It's the same that's in the criminal trials that defendants bring daily is, you know, become a 13th juror, read the record, and then determine credibility from reading a cold record, which is nearly impossible. And that's why the standard is nearly impossible to overcome. And
the charged offense was trafficking, correct?
yes,
Is the state's position that there was insufficient evidence that they were convicted of the charged offense or some lesser included offense?
we think that it's both. We think that there's sufficient evidence. Of course, this court earlier reversed the convictions,
Right.
but the standard is not did they quite meet every element. It's did they engage in any criminal activity at all, and that's.
But it has to be the charged offense or a lesser.
Yes,
It
yeah,
can't
and
be
that's.
something outside of that, like possession of.
Well, if you read the Gopher decision, the Gopher decision certainly doesn't indicate that. The Gopher decision says, and I'm paraphrasing here because it's been a while since I read it, but someone that's free from criminal behavior. And that clearly is not what we have here. Hoysek testifies that they went to Willard, 92 Willard, to get high, that they laid out 4 lines of meth, that they blew the meth off the speaker.
And then, now, as to the court's analysis, did it include a conclusion and analysis that Ms. DelRossi failed to prove that she was not guilty of the possession of methamphetamine, let's say, because of the pink purse and all everything in there, or possession of drug paraphernalia or whatever? Does the court go into that analysis, I guess is what I'm saying?
Yeah, I believe the court said there was clearly criminal activity here, afoot here.
Okay.
And then under Gopher, that's all the state had to show, that these people were not victims of wrongful imprisonment. Rather, they were able to, fortunate for them, beat their charges. But that's not what the General Assembly was intending to compensate. Not folks that beat their charges, but rather folks who spend time in prison who were factually innocent of the crimes that they were charged. In this case, there was it appears the prosecution had a stronger case for possession than they apparently did for trafficking, and they were able to beat their criminal charges based on that, but that doesn't necessarily translate to they were actually innocent for purposes of the A5 prong in order to obtain compensation. And Judge Oldfield didn't lose her way by recognizing as such. Unless the court has any further questions, the state will rest.
I'll have to look at the entry as to what the court said.
Yes, sir.
You're saying that she held that Ms. DelRossi did not demonstrate by a preponderance of the evidence that Ms. DelRossi, did not commit the offense. I don't know. Is that the language she used, or did she say any criminal offense?
It finds that
Which would bring it under that statute.
Ms. DelRossi and Mr. Morlock have failed to affirmatively prove their innocence by preponderance of evidence as to the offense of illegal manufacture of drugs in violation of 292504 in the illegal assembly or possession of chemicals for the manufacture of drugs in violation of 2925 period 041A.
So she limited it to those two charges.
Yes, she did limit to those two charges, but Gopher, I think this court could
She
affirm.
didn't apply Gopher.
That, well, the state certainly raised Gopher,
Yeah.
and this court has the authority when it reviews a judgment, especially for the appellee, to say, well, I may disagree with the basis for affirming the judgment, but I'm still going to affirm the judgment nonetheless. And courts do that all the time.
Sure they do, but what if it's a situation where the court applied the wrong law or the wrong standard?
I think
Your argument is that's not the
under
case here.
Gopher, I don't believe that's the case here. I don't think the court applied the wrong standard, and I think the court found that there was that the witnesses for the state were more credible, that criminal activity had occurred here, and that Mr. DelRossi and Mr. Morlock were lying, and she basically made that finding. She made that finding that they were not credible.
But what affirmatively showed that they were, what evidence was there before the court that affirmatively showed that they were involved in trafficking or possession of meth?
Well, they were present at Willard where meth was being manufactured, or the materials were there so that meth could be manufactured. And also, that she found that Angela Hoysek was present with them at that residence, and they were there to get high, and that DelRossi and Morlock brought Mr. O'Connell supplies to make meth, including Sudafed. So,
In the past,
no,
that day?
that day. Oh, no, within a week prior, within a week prior, they brought methamphetamine, and that's why I believe this court previously found that reversed their convictions. So, we think there's a distinction between beating your charge and being actually innocent for the purposes of the statute.
Thanks.
Does it have to do with the standard as well as beyond a reasonable doubt and preponderance of the evidence?
Sure,
Why would that-
I mean, they have to, in this case, they have to affirmatively prove that they were innocent of these charges. And because DelRossi and Morlock were found not to be credible, that their testimony was not credible, and that the testimony of the police officer and the Ms. Hoysack was credible, they found for the defendants in this case. She found for the defendants in this case.
No, I'm good, thank you.
All right, thank you.
Thank you, Your Honor.
What about that argument that the judge was just
Well, let me
weighing
start.
credibility of the witnesses?
And I think that she obviously has a right to weigh the credibility of the witnesses. I think that, and I understand the argument that the position of this court is in, and I recognize that. I also understand that when you read the record, you will find that even in, that, first of all, to say that my clients are absolutely uncredible and unreliable, and that every statement that they made is pulled from whole cloth, as if made from his fabrication, is unsupported by the evidence here. The other witnesses, whom she's silent about, Mr. Connell, Ms. Peltz, clearly support the argument and the evidence put forward by my client. There is the Officer Crockett regarding any of the actual evidence presented here, while his testimony is credible, does not speak to any of the facts in this case that my clients were there to charge with. And I want to clarify, the issues at hand and the offenses at hand are manufacture of methamphetamines and possession of chemicals for the manufacture of drugs, not trafficking or possession. Those are subsequent, potentially other charges that could have been brought based on the facts in the case, which brings us to the distinction between the fifth and the fourth section of, and I think I misstated and cited one of the criminal offenses. 274348 is the statute for wrongful imprisonment. Prong 5, which we're dealing with here, is subsequent to sentencing, that it was determined by the Court of Common Pleas in the county where the underlying criminal action was initiated, that the charged offense, including all lesser included offenses, either was not committed by the individual or was not committed by any person. So the charged offense under subsection 5 is manufacturing and possession of chemicals. Those are the issues at hand. And so which is what the judge cites in her opinion. Those are the two opinions under subsection 5.
Contrary to Gover.
And Gover speaks to the fourth prong, which my argument is that is not before this court here. And Gover, as I argued, and the reason why I'm bringing that up here is because I made substantial arguments at the trial level that Gover is no longer, or is at least needs to be considered as good law, as the standard by which this is measured. There have been changes to the language. The 8th District has basically reversed Gover at this point, and is no longer holding it to be good law. That evidence is in the record in the motions for and summary judgment and pretrial statements. That evidence is there at this court. Obviously, that's not what I raised as the issue here. It's not what was raised at the trial level. My position is that this matter needs to be remanded for consideration of that fourth prong under Gover and the state of the law. And if this court wants to hear that himself and feels it has the ground, I would ask perhaps an opportunity to supplement the argument. But I believe that would need to be remanded and we heard before even you could hear it on a de novo basis. So then, and I think that the trial court, as you heard in the record, did not say that there were other offenses that could have been charged. They clearly articulated what is the fifth prong, and that my clients have not met their burden. I dispute that is valid, and I believe that is against the manifest weight of the evidence. I do agree that, I agree first that yes, this is a different standard than what the state had to prove. As I said, they obviously at trial did have to prove that my clients were not guilty beyond a reasonable doubt. They did not do that. I also know that in that record, as here, this court held that the state had put forward no evidence that my clients had been involved in the manufacture of meth or the possession of chemicals on or about the 28th of October, 2012. And
Same trial court judge, just out of curiosity?
What's that?
Was it the same trial court judge?
No, this is heard by different trial.
All right, with that, your time is over. Thank you both of you for your presentations. We will take the matter under advisement. We'll issue a written decision, which will be mailed to both sides and will be posted on our website and on the Supreme Court. Thank you.
Thank you.
Thank you, I appreciate it.
Thanks for making the trip.
Thank you.